Welcome to News Hour by DLC, your one-stop destination for the latest and most impactful updates from the legal world. From landmark rulings to policy shifts shaping the justice system, DLC brings you in-depth coverage, expert insights, and analysis that matter. Stay informed, stay ahead because in law, every verdict counts. Today is 24th February 2025 and we bring you news that matters. The first news for today is as follows. In a significant ruling, the Supreme Court of India has underscored the paramount importance of personal liberty, cautioning lower courts against the unwarranted cancellation of bail. The apex court emphasized that an individual's freedom as enshrined under Article 21 of the Constitution should not be curtailed without substantial justification. The bench comprising Justices Dipankar Dutt and Manmohan set aside a High Court decision that had revoked the bail of an accused charged with attempted murder. The Supreme Court observed that in the absence of evidence indicating misconduct by the accused post bail, such as influencing witnesses, tampering with evidence, or employing delay tactics, the High Court lacked valid grounds to cancel the bail. The justices stated, liberty of an individual being a precious right, under the Constitution the courts ought to be wary that such liberty is not lightly interfered. They further noted that the High Court had overstepped by effectively conducting a mini-trial during the bail cancellation proceedings, rather than focusing on any new evidence or misconduct warranting such a decision. This ruling reinforces the judiciary's commitment to safeguarding personal liberty and serves as a directive to lower courts to exercise restraint and adhere to constitutional principles when deliberating on matters of bail. Next news. In a significant legal development, the Supreme Court of India has consolidated multiple first information reports, FIRs, filed against YouTuber Savuku Shankar stemming from an online interview. The bench led by Chief Justice Sanjeev Khanna and Justice Sanjay Kumar directed that all FIRs related to the interview be merged, with primary investigation centered on FIR No. 123, 2024 from the Imber Cyber Crime Police Station. During the proceedings, Senior Advocate Siddharth Luthra, representing the state of Tamil Nadu, informed the court that Shankar had violated a previous order prohibiting him from commenting on court proceedings. In response, Shankar's counsel, Advocate Balaji Srinivasan, conveyed his client's unconditional apology for the remarks made. The court emphasized the importance of adhering to its directives and cautioned Shankar against making any further statements regarding ongoing legal matters. This ruling underscores the judiciary's commitment to upholding the integrity of legal processes while balancing individual rights to free expression. Next news. In a recent decision, the Supreme Court of India dismissed a public interest litigation, PIL, seeking regulation of internet service prices. The bench comprising Chief Justice Sanjeev Khanna and Justice Sanjay Kumar emphasized the competitive nature of the market, noting the availability of multiple service providers, including BSNL and MTNL. The petitioner argued that a significant market share is held by a single provider, but the court suggested that such concerns be addressed through the Competition Commission of India. The petition was dismissed, granting the petitioner liberty to pursue alternative statutory remedies. Next news. In a recent directive, The Supreme Court of India has summoned the Chief Secretary of Rajasthan to appear via video conferencing on the 17th of March 2025 due to the state's non-compliance with a prior order concerning the restoration of wetlands in Dhum city under the Smart City Development Mission. The bench comprising Justices Abhay S. Aukar and Ujjal Bhuyan expressed concern over the state's defiance, stating, "We wonder how a city can become smart without protecting the water bodies, wetlands in the city." The court emphasized the necessity of safeguarding natural resources as an integral part of urban development and warned of potential contempt proceedings if compliance is not demonstrated. Next news. In a landmark judgment, the Supreme Court of India has ruled that personal appearance is not mandatory in proceedings under the Protection of Women from Domestic Violence Act 2005, DV Act. The court quashed a lower court's directive that had initiated extradition proceedings against a husband residing in the United States for failing to appear in person. The bench comprising Justices Pankaj Mithal and Sandeep Mehta emphasized that proceedings under the DV Act are quasi-criminal in nature and do not necessitate the physical presence of the parties involved. They further noted that such proceedings do not carry penal consequences unless there is a breach of a protection order under Section 31 of the Act. The case originated from a matrimonial dispute where multiple legal actions were filed by both parties across various jurisdictions in India. The husband residing in the US was directed by a judicial magistrate in her West Bengal to appear personally in response to a domestic violence complaint. Upon his non-appearance, the magistrate ordered the initiation of extradition proceedings, a decision later upheld by the Calcutta High Court. Challenging these orders, the husband approached the Supreme Court. The apex court observed that the trial court had erred in mandating the appellant's physical presence, especially considering his passport had been impounded, rendering him unable to travel. The court stated, as the proceedings under the DV Act are quasi-criminal in nature, there cannot be any justification to require the personal presence of the appellant in these proceedings. Additionally, the Supreme Court highlighted that the impoundment of the appellant's passport was ex facie illegal, as it violated principles of natural justice by not providing the appellant an opportunity to be heard. The court directed the relevant authorities to release the impounded passport within a week. In a significant move, the court also dissolved the marriage on the grounds of irretrievable breakdown, noting that the couple had cohabited for only a brief period and had been living separately for over 5 years. The husband was ordered to pay a one-time permanent alimony of 25 rupees lakh to the wife. All pending civil and criminal proceedings between the parties were directed to be closed. This judgment underscores the Supreme Court's commitment to upholding individual rights and ensuring that legal proceedings do not become instruments of harassment, especially in cases where the accused is unable to appear due to circumstances beyond their control. Next news. In a recent ruling, the Supreme Court of India emphasized that judicial interference in recruitment processes is unwarranted when the appointing authority has accepted a candidate's qualifications as meeting the prescribed criteria. The bench comprising Justices P.S. Narasimha and Manoj Mishra stated that unless there is a glaring discrepancy between the specified qualifications and those possessed by the candidate, courts should refrain from setting aside such appointments. The case in question involved the Department of Electricity in Lakshadweep, which had advertised for the position of junior engineer requiring a diploma in electrical engineering. The appellants, holding diplomas in electrical and electronics engineering, were selected for the role. However, respondents with diplomas in electrical engineering challenged these appointments, arguing that the appellants' qualifications did not align precisely with those specified. Both the Central Administrative Tribunal and the High Court ruled in favor of the respondents, leading the appellants to approach the Supreme Court. Upon review, the Supreme Court noted that the recruiting authority had sought and received clarification confirming the equivalence of the two diplomas prior to making the appointments. The court underscored that determining the equivalence of qualifications falls within the purview of the employer, not the judiciary. Citing the precedent set in Union India v. Uzair Imran 2023, the court reiterated that it is not the function of the court to determine the equivalence or two qualifications. This judgment reinforces the principle that in the absence of evident discrepancies or illegality, courts should exercise restraint and respect the appointing authority's discretion in matters of candidate qualification and recruitment. Next news. Delhi High Court upheld the refusal to grant a patent to the Regents of the University of California for a recombinant Salmonella microorganism-based live vaccine intended to prevent enteric bacterial infections. Justice Amit Bansal observed that the patent application lacked specific disclosures regarding insertion or substitution mutations in one or more nucleotides within the genes. The Assistant Controller of Patents and Designs had previously denied the patent on grounds that the application did not meet the mandatory requirements outlined in Sections 10(4) and 10(5) of the Patents Act, 1970. Additionally, it was determined that the claimed subject matter was ineligible for patent protection under Section 3(c) of the Act, which excludes from patentability the mere discovery of scientific principles or natural phenomena. Upon reviewing the application, the court noted that the claims encompassed various types of loss-of-function mutations in selected genes of Salmonella microorganisms. The broad scope of the claims suggested that the target genes did not require deliberate mutation, as long as the expression of the native gene product was functionally disrupted in some manner. This expansive scope raised concerns about potentially covering naturally mutated Salmonella strains, which are not patentable under Section 3(c). The court emphasized the necessity for sufficient disclosure to clearly define the scope of the patent application, ensuring it does not encompass naturally occurring mutations. In the absence of such detailed disclosure, the application was found to lack the requisite inventive contribution, leading to the dismissal of the appeal. This ruling underscores the importance of precise and comprehensive disclosures in patent applications, particularly in the biotechnology sector, to delineate the boundaries of claimed inventions and comply with statutory requirements. Next news. In response to the Allahabad High Court's suggestion, the UD government has broadened the mandate of the Judicial Commission investigating the 29th of January stampede at the Mahakumbh in Prayagraj. The expanded scope now includes a thorough inquiry into the loss of life and property resulting from the incident. The commission, led by retired Allahabad High Court Judge Justice Harsh Kumar, will also assess the coordination between the Mela administration district authorities and health services during the event. This decision aims to ensure a comprehensive and transparent investigation into the causes of the stampede and to develop measures to prevent similar occurrences in the future. This development follows a public interest litigation, PIL, seeking detailed information on individuals missing after the tragic event. The High Court had previously advised the state government to clearly define the Commission's terms of reference to encompass all relevant aspects of the incident. The stampede, which occurred on the 29th of January, resulted in numerous fatalities and injuries among devotees attending the Mahakumbh. The expanded inquiry is expected to provide clarity on the incident's circumstances and offer recommendations to enhance safety protocols for future events. And the final news for today is as follows. In a recent decision, the Nara High Court permitted the Rashtriya Suraksha Janandolan Samiti, Mysore to conduct a peaceful rally within the Mysore football ground. This rally, termed Mysore Chalo, was organized to protest a recent stone pelting incident at the Udayagiri police station. The court directed the Mysore Police Commissioner to relax the Section 144 CRPC order in the area to facilitate the protest, scheduled for approximately 3 am on February 24, 2025. Justice R. Devdas emphasized that the rally must remain peaceful, cautioning against any provocative statements that could incite communal tensions. The petitioner was required to post a bond of ₹1 lakh and ensure the event was videographed. This ruling aligns with previous directives from the Nara High Court, which have sought to balance the right to peaceful assembly with public order. Notably, in March 2022, the court instructed the state government to restrict protests and rallies to designated areas, such as Freedom Park in Bengaluru, to prevent traffic disruptions and maintain public safety. The court's recent decision underscores its commitment to upholding citizens' rights to peaceful protest while ensuring such activities do not compromise public order or safety. Thanks for listening and consider subscribing to the channel. Well, that's all for today. Keep listening to Legal News by DLC.